Hello there. This is An Architect Goes to Law School. Today in civil procedure class, we'll talk about procedural and affirmative defenses in the initial pleadings. As a reminder, once a defendant is served with a complaint, they're required to file an answer with the court that is then transmitted to the other parties. Answers can contain various pieces of information such as confirmation or denial of any or all of the allegations in the petition, as well as counterclaims and cross-claims made by the defendant against other parties. Denials of the claims can be general or specific. It's common for a defendant to include a general denial of the claims so as to require the plaintiff to prove all the claims in court. Procedural defenses, such as lack of subject matter jurisdiction, improper venue, and insufficient service of process, for example, are controlled by Federal Rules of Civil Procedure, Rule 12b. Possibly most importantly, FRCP 12b-6 is failure to state a claim upon which relief can be granted, and is a collateral attack on a petition's sufficiency. Importantly, an answer to the petition is an opportunity to state an affirmative defense. Affirmative defenses are a class of defenses that are waived if not asserted in the answer. The list of affirmative defenses includes, but is not limited to, accord and satisfaction, arbitration and award, contributory negligence, estoppel, failure of consideration, fraud, illegality, injury by fellow servant, laches, license, payment, release, res judicata, statute of frauds, statute of limitations, and waiver. Some of these defenses require explanation here. Accord and satisfaction is a concept in contracts whereby two parties modify their original contract to change the terms, the new terms of which have been allegedly fulfilled. For example, if a contract to sell a car is modified by both parties' agreement to include a trade-in, which is properly delivered, and the seller then wants to enforce the original contract, the buyer may assert the defense of accord and satisfaction. Arbitration and award is meant to prohibit an attack on a completed binding arbitration result. Estoppel is a defense where one party avers that there is a reason why the plaintiff should not be allowed to bring the suit in the first place. This reason is that the issue at hand has already been litigated and decided. Failure of consideration means that in the contracting process, one party's promise is insufficient to complete the creation of the contract. Laches means that a party has waited too long to bring suit, essentially having given up their right to do so, even if the statute of limitations time period hasn't passed. License as a defense simply means that the defendant was given permission by the plaintiff to engage in a particular action. Res judicata is the legal doctrine that a particular claim has already been decided by a court and can't be relitigated. The statute of frauds defense relates to a doctrine that some contracts are required to be in writing to be enforceable. 4 categories of these contracts include agreements for transfer of real property, sales of certain goods, surety agreements, and contracts where performance is meant to be completed in more than 1 year. While it is the attorney's specific role to draft the answer to a complaint, it is a best practice for an architect facing litigation to fully assist and facilitate the drafting by providing information that may lead to the assertion of affirmative defenses. Feel free to comment, ask questions, and suggest topics you'd like me to discuss. Next up, we'll discuss the discovery phase of lawsuits. Thank you for watching An Architect Goes to Law School.